Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the American Bar Association, Antitrust Law section. My name is John Roberti, and today's topic is, how was the case won? An inside look at the Sprint T-Mobile merger trial. In the antitrust world, most mergers are quickly approved. Most of them go through without competition issues. A small percentage is given a more detailed review. In the U.S., we call that a second request. But most of those cases are ultimately settled or approved, or the agencies let it go through. In a very small number of cases, it's really just a few each year, if even that, there is ultimately a trial. And that is a big event in the antitrust world. The trial itself typically becomes a huge effort, generally life-consuming, for the teams of lawyers and paralegals and economists from both the government and from the parties that are seeking to merge. So we don't often get a lot of chances to talk about these big merger trials. But there was one that was sorted out earlier this year, and it involved a merger between Sprint and T-Mobile. High profile, much in the news. Today, we are very lucky to have a chance to speak with two of the lawyers responsible for getting that deal through. My co-host today is Sergei Zaslavsky. Hi, Sergei.
Hi, John.
Sergei, what are we doing today?
We are going to be talking about a very interesting merger case that was tried in December 2019 and decided in February of this year. As you mentioned, it's the Sprint T-Mobile merger. And we're going to get an insider's perspective on how the case was litigated and won by the merging parties.
Sergei, why is this important?
Well, for antitrust nerds or merger litigation nerds like me, every merger case that goes to verdict is a very big deal. As you said, these cases are very rare. You generally only get a couple a year that go to trial, if that. They're always fascinating because there's so much in the line and the litigation happens so quickly. This one is particularly interesting because it is a very unique posture. The federal agencies actually cleared the merger, and it's the state AGs that sued to block the merger, making it a pretty unusual case. But cases like these are not just for antitrust nerds. They have a much broader significance because the outcome really matters for the economy. Mergers, especially large mergers such as this one, can be very transformative, both for the companies involved and even for the whole industry. So a lot rides in the judge's decision on whether to allow a merger to proceed.
Who are our guests today?
Well, we are very lucky to welcome two lawyers who represented T-Mobile and played an important role in the Sprint T-Mobile trial. We have George Cary, a senior partner at the Cleary firm and a man who really needs no introduction in the antitrust world. And we have Lindy Bernhardt, an associate at the Cleary firm who worked on the case.
Sergei, I'm particularly excited about this one because a lot of times what people hear about in the antitrust world are these big trials. If you ask sort of a person who's not in our world about what's going on in antitrust, a lot of times you'll hear about these big merger trials. So really excited to learn more. Let's bring in our guests. George and Lindy, welcome to the program.
Thank you very much.
Hi, George. Most listeners are probably pretty familiar with the Sprint T-Mobile merger. It's certainly been in the news a lot. But could you provide a very brief summary just to set the scene so everybody's on the same page, the history of the transaction and how we got to litigation?
Sure. So the U.S. wireless industry was comprised of four firms: AT&T, Verizon, T-Mobile, and Sprint, in terms of network carriers. Four network wireless carriers About 8 or 9 years ago, there was a merger proposed between number 2 AT&T and number 4 at that time T-Mobile, which the DOJ opposed, filed a complaint to try to block the deal, and then the FCC ended up challenging the deal, and the deal fell apart. T-Mobile and Sprint began discussing the possibility of a merger shortly thereafter and negotiated over a number of years. In around 2014, they actually had a visit with the head of the Antitrust Division of the Department of Justice, who was quite discouraging about bringing the deal forward. The FCC similarly signaled that it was not enthusiastic about the transaction. Nonetheless, the parties believed that the business logic of the deal was just so compelling that if they could arrive at a deal, they would present it in full glory with a full backup of information and detail, because they thought there was a chance that they could get it approved, notwithstanding the priors of the DOJ and the FCC. So the parties continued to negotiate. Eventually, they were able to arrive at a deal after SoftBank had acquired Sprint and had suffered losses for many years and had figured out that their turnaround plan was just not going to work. That deal was then presented to the agencies, and the rest is history.
Well, it sounds like it's been a long time in the making. And as you mentioned, the two federal agencies, DOJ and FCC, signed off on the deal with conditions. But here it was the state AGs that decided to file suit. Were you surprised at the state's decision to file suit when things appear to be going well with the federal agency? Or was it apparent fairly early in the investigation that states and the federal government could be on divergent tracks in this deal?
It was pretty clear early on in the investigation that the states were going to chart their own course. They were not taking the typical role, which was attending DOJ meetings, listening, tagging along, asking a few questions. That happens frequently in merger cases where the states and the DOJ work together. This was very different. The states from early on had set their own pace, had set their own agenda. There were numerous separate meetings with the antitrust staffs in New York and California, separate and apart from the DOJ meetings. Different questions were asked. The states retained their own technical experts as well as economic experts. So we knew from very early on that they were charting their own course, and that unlike the typical case, resolution with the DOJ did not mean resolution with the states. So while we were disappointed that they came to the conclusion that they came to, and while we thought their conclusion was wrong, we were not surprised when they brought the lawsuit.
So when the states brought the lawsuit and it first started planning your defense, what was your view of the case? What did you see as your biggest strength and your biggest vulnerabilities or weaknesses as you started preparing the case?
Yeah, so there was one compelling strength of the case. And that is that because of the way that cellular networks work, because of the unique radio frequencies that the two companies had, if you put these together, they were hugely synergistic, hugely complementary. So Sprint had a whole stash of spectrum that was underutilized, that was great for capacity. The reason it was underutilized was because they did not have the kind of spectrum that's necessary to give you great coverage or to penetrate walls well. So customers weren't happy with the service, to be blunt. The result was that they were losing customers and they had much more capacity than they needed. T-Mobile had exactly the opposite situation. They had the kind of spectrum that allowed for great coverage and great penetration, but they were running out of capacity because customers really liked their offering. The combination of those two things, of those two companies putting together capacity with coverage in a way that neither company could do on its own, was a compelling fact. So we knew from the beginning that the case would rise or fall on whether we could prove that synergy. The weaknesses are, as you might expect, a 4-to-3 concentration, a prior position by the DOJ that 4-3 was unacceptable from a competition point of view, albeit in that case involving one of the leaders rather than the two smaller companies. The difficulties were that there was a presumption that this would be anti-competitive. The strength was that we felt confident that we could demonstrate that putting these two things together was better for consumers than keeping them apart.
George, this is a really important point, and I want to maybe take a step back. And one of our very early episodes on our Curious Amalgam, we talked to a lawyer who had done a number of merger trials about what's important to do it. And one of the things she taught us was the key part of all of this is storytelling, being able to explain things that are really complicated in a simple way. And Lindy, George, how did you go about wireless technology? Sounds pretty complicated to me. How did you go about figuring out a way to tell a story that a very smart federal judge, but nonetheless a layperson, could really understand and sink his teeth into?
Well, we were blessed with a couple of really, really excellent witnesses. The chief technology officer of T-Mobile and the head of network planning for T-Mobile, Neville Ray and Ankur Kapoor. They had the knack of being able to take what could be very complicated physics, network physics, very complicated concepts about spectrum and wavelengths and capacity formulas and how these networks worked. And they were able to explain it in a way that even I could understand. And if I could understand it, then a smart federal judge would have no difficulty. And they told a compelling story. They also were able to tie that story about how the network physics works with the way they operate their business, decisions they'd made in the past, how they made those decisions, what tools they used, which made it all very real, very concrete, and very understandable, I think, by the judge, as demonstrated by his 175-page opinion.
Yeah, so it's interesting that you mentioned the important role that synergies played in the case, and that really comes across when you read the opinion as well. Now, there's a distinction between efficiencies, the doctrinal concept of efficiencies, which require very specific showing under the merger guidelines, verifiable, merger-specific, passed through to consumers, and the broader rationale for a deal. And I think that there is a view that, with efficiencies, all merging parties feel they have efficiencies and they make that a part of the case. But it's very, very difficult to prevail at trial just based on efficiencies. Whereas the broader rationale for the deal is usually an indispensable part of the case, just because there's a risk that if the judge is not convinced that companies are merging for a pro-competitive reason, that raises the inference that they may be merging for something that is less than a competitive reason. Did you draw the distinction between the cognizable efficiencies and a broader deal rationale as you were planning for the case? And did you make a choice to focus on one versus the other? Or did you just say, our efficiencies are so compelling here that even though they usually don't carry the day in court, this could be an exception where efficiencies will play an important role?
Well, we did both, and we were very lucky because the efficiencies that we had here did translate directly into marginal cost reductions. So first we told the story about how when you combine these networks, you literally, as a matter of network engineering, end up with much more capacity than if you keep these same assets separately. So by combining the network, you actually multiply the amount of capacity that the network can handle. And that was the network physics story that Mr. Ray and Mr. Kapoor told so well. That's the starting point. So you take 1 + 1 and you end up with 6 in terms of total capacity available. At the same time, when you dismantle the Sprint towers and load all of the spectrum of both companies on the T-Mobile tower plus fill-in towers from Sprint, you get huge cost savings. So that's the overarching picture. Now, going to your point, Sergei, which is exactly right, how do you translate that into a merger guideline type of analysis? Well, again, we were blessed with the fact that in operating their business, these companies have to keep track of where their assets are, what their network looks like, what the load is, how much capacity they have, and how much they expect to get, because they don't want to be in a position where people pick up their phone and they don't get coverage. They get calls dropped, they can't download data, etc. So they have a tool that predicts which cells are going to get congested when, and the tool then says, given this prediction, here is the solution. The engineering tool was demonstrated, and Mr. Kapoor testified to this, to be 99.4% accurate in terms of predicting capacity needs in the future. And that was historical fact, so very concrete. The economists in the case were able to take that model and ask the question of the model, if you supplemented the network with the Sprint assets, when would you need to update your capacity, and how much would that cost relative to what you're predicting it's going to cost on a standalone basis? That gave them the marginal cost savings that would come out of the transaction, which they were then able to apply against the guppies that Professor Shapiro put forward and demonstrate that the deal was pro-competitive.
Sorry, let me just pause you. Could you explain what the guppies are? Some people in our audience may not be familiar with some of the antitrust lingo.
Sure. So the guppies are a prediction of the gross upward pricing pressure that might result from a transaction, which is based on a formula that basically says if you can combine two companies and therefore not have to compete and be able to keep customers that you otherwise might lose if you were to raise a price, what is the incentive to raise prices? How much upward pricing pressure is there, and how much will prices go up? The plaintiff's economists said that if you combine these two companies, because they compete, there will be a guppy that will result in a price increase to consumers. That is the case unless you have offsetting marginal cost savings, which create powerful downward incentives to lower price. And our economists took the upward pricing pressure put forward by the other side and said, but when you take into account these cost savings, in fact, prices are going to go down. I'd like to make one other point on this because I think this really gets to the heart of the matter. And I guess I'd like to invite Lindy to speak to how these network efficiencies, how these cost savings were also documented in the company's business plans.
Lindy, do you want to weigh in?
Sure. And I think one related point, too, that I think is important to mention is that there was a prior successful integration when T-Mobile acquired Metro PCS. So that went to the verifiability of the efficiencies and how these would play out in real life. And as for how the companies sort of documented the network efficiencies, it was clear in their ordinary course documents and some of the stuff we were seeing at trial that these weren't just ideas that were only connected to this merger and didn't have anything to do with their business. It was clear that they were using these ideas and using these efficiencies to create their business plan, and that it was the entire motivation for the deal. And it's what made the deal made sense for them. So it wasn't just speculative things to put forward at trial. It was actually what they were using in their business, which made it all the more compelling.
Yeah, well, it sounds like you guys had a really good set of facts to work with here, because usually one of the things about merger litigation that can strike people as unusual is that, unlike in most cases, you're not trying to figure out what happened in the past. You're trying to predict the future. And more than one judge has referred to having to gaze into a crystal ball to decide a merger case. And I guess here you guys had the facts and you picked the right strategy to get the judge more comfortable with gazing into the crystal ball, because there was something that in the parties' ordinary course documents and strategy that allowed the judge to feel comfortable with a prediction on what the parties would do after the merger. Did you find that to be the case? And how did you try to best take advantage of that theme?
Yeah, I think that's absolutely right, Sergei. First of all, the kinds of efficiencies we were talking about here were not, procurement efficiencies. I shouldn't say they were not. They included these things, but this was not the heart of the matter. They were not things like procurement efficiencies where volume purchases meant you save 5% on your inputs, or distribution efficiencies where you saved 7% because you could work out your logistics in a more efficient way. They were things around the edges that were relatively small increments. I mean, we're talking about tripling the output from the same inputs. We're talking about sea change in terms of the economics of the firm, talking about marginal cost 1/7 of what the pre-existing firm would have been required to charge given their costs. So you're absolutely right. These were overwhelming kinds of efficiencies that went to the heart of the product that was being produced. Second point, I think that is critical in all of these cases is, again, if you ask the judge to predict between two future views of the world, both based on theoretical models, I think it's easier for the judge to conclude that the elimination of competition is more real, more concrete than possible efficiencies. But as Lindy pointed out, if you ask the judge instead, you can speculate about elimination of competition going forward, or you can look at the realities of what has driven pricing and costs in the past and come up with a prediction of what will happen if you make the following changes. I think the battle of concreteness then shifts over to our favor. And I think that's really what marked the distinction between this case and most. In most cases, the battle of concreteness goes in the favor of the government with a simple showing of elimination of competition. And here we had the better of that argument.
Yeah, the opinion was actually quite interesting, where the judge explicitly said that he felt the experts more or less canceled each other out, and he looked to the credibility of the company executives in deciding what would happen after the merger. While I've heard antitrust lawyers, say similar things, it was a little unusual to read that in an actual opinion, just because, in antitrust law, economics plays such an important part. And I work with experts a lot, so I don't like to think that experts just cancel each other out. I like to think that they're a very important part of the case. Do you think that going forward, this opinion will be influential in terms of increasing the importance of company witnesses? They're important already, of course, but increasing it even more and somewhat de-emphasizing economics in merger cases? Or do you think it was a fairly unique set of circumstances here that led to this outcome?
Well, I'm going to respectfully disagree a little bit with the judge. Obviously, he's the decision maker, so his opinion matters. But I'm going to say the following. While it is fair for him to say that the bottom line conclusions of the economists canceled each other out, and therefore he fell back on the business people, I think the economic framework here was critical, as demonstrated by the questions you previously asked. Efficiencies don't mean anything in a merger case where the test is a substantial reduction in competition, unless the judge understands what the import of those efficiencies are on the competitive environment. And the way for the judge to understand that import is to listen to economists, and he did that in this case. Without that, the efficiencies would have been treated like they were in the Procter & Gamble case in the 1960s, as an irrelevant sideshow that have nothing to do with the main question, which is what's the impact on competition. So here I think the economists were important, and they were important in terms of setting the framework, getting the judge to understand what questions he needed to answer, And in that sense, I don't think the economists canceled each other out at all. I think the economists reinforced each other. So I think a big part of the case was the fact that Professor Shapiro acknowledged that which he had to acknowledge as one of the authors of the merger guidelines, that efficiencies matter, that efficiencies can reverse the outcome from an anti-competitive one to a pro-competitive one, that one has to take those into account, and that if you do not take those into account, the court can make a mistake and block a merger that would actually help consumers. He testified to all of those things. What Michael Katz did, our economist, was to satisfy the court that in that framework, the efficiencies were so large that he could feel comfortable. Now, understanding that framework, he was then in a position to say, when the CEO of T-Mobile tells me he's going to lower prices, and when the COO of T-Mobile explains to me why he's going to do that, what the business logic of that is, and when that flows from increased capacity and lower costs, and the CTO explains how that comes about, Dr. Shapiro and Dr. Katz tell me that that's significant. So I don't think he ignored the economists at all. I think he applied the facts, found the facts from the fact witnesses, and then applied the analysis that Professor Shapiro and Professor Katz suggested he should apply.
Yeah, it sounds like it's the interrelationship between the economists and the fact witnesses that was key here, that the economists set up the framework for the right questions to ask, and then that allowed the judge to incorporate what he heard from the fact witnesses in the right framework to help him answer the questions that needed to be answered.
Exactly.
Lindy, I would like to hear from you. Merger litigation is a really, really unique experience. You have 3 years of litigation that's compressed into about 3 months of litigation. It's really unlike anything else that associates or lawyers in general do. What are the most important lessons that you learned, and what advice would you give an associate who may be facing the prospect of doing a merger case for the first time?
Something I learned very quickly is that in a case like this, where there's so much to do and it's on such a compressed timeline, is that there really isn't time to be shy. The fact of the matter is the associates are the ones who often have the best handle on certain categories of facts and they're closest to the documents. And some of the best ideas on our team came from the associates who were so familiar with some of this information and had really good ideas as to arguments to make. Everyone on our team played a really critical role. So the advice I would give is that if you're an associate on a team like this and you have an idea, a good line of questioning for cross or a good document to use on direct that you're really familiar with, speak up, because some of those ideas otherwise just won't come around. And I definitely learned that very quickly. And I thought it was a really good opportunity to learn and develop these skills that I probably wouldn't have gotten to take advantage of otherwise. So if you get an opportunity to work on a case like this, my best piece of advice is just take full advantage of the opportunity.
That's great advice, Lindy. I find that the more facts matter, the bigger role associates tend to play, and facts matter a lot in antitrust and merger cases specifically. And also the faster things move, the more opportunities there tend to be for associates, and things move very fast on merger cases.
Lindy, how long did you work on the case from from beginning to end?
So I joined in January of 2019, and I actually felt like a very latecomer to the case at that point because it had already been going on since I think the deal was announced in April of 2018. So I thought I was joining near the tail end. Little did I know that 6 months later, it would turn into merger litigation. And by the end of the year when we were at trial, I felt like I'd been on this case as long as anyone else on the trial team. It was definitely a fast-paced environment, but probably one of the most rewarding things I've had the opportunity to work on.
Did you ever find yourself, Lindy or George, wanting to explain to your family about how wireless networks work? And, we just drove and we must have just switched networks because this happened or that happened, and run into the the deafening silence of disinterest? Because that's happened to me in similar circumstances.
Definitely. I've pointed out frequently antennas I've seen on buildings, or I would see ads on TV, and my husband and my parents could not care less. But it's the fun thing about working on a case like this is it's so connected to real life and things that you use every day and things that you see every day. That part of it was really fun.
My wife used to pretend she was interested, but that wore off. Well, I didn't work particularly on this case, but in some of the odder things I've worked on, she used to pretend she was interested in that, but lost patience pretty quickly. George, maybe we can shift gears just a little bit. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Well, okay. I'm going to tell you something that is quasi-professional. So my first legal job was as an administrative law judge in some of the most remote areas of Appalachia, hearing claims from coal miners who had been denied their pensions and were appealing. It's a very long story about the shenanigans and infighting that led to these hearings, but it was one of the most fascinating experiences of my life. And I think one of the more interesting aspects of it is that I did this between my second and third year of law school. So I was not even a full-fledged lawyer yet, and I was serving as a judge, which was quite a trip.
How did that opportunity come to be?
Well, it's a long history, but there were infighting between different factions in the United Mine Workers, which resulted in an upstart candidate for president getting murdered and his family getting murdered by the incumbents. It turned out there was a lawyer at Arnold & Porter that was doing pro bono work and started digging into it and found out about the corruption of the United Mine Workers. In fact, there's a whole book called Night Comes to the Cumberland about this whole episode. But the upshot was that Tony Boyle, the head of the UMW, was siphoning off money for his own purposes and was denying coal miners their pensions in order to keep that flow of money coming. And when it all came to light, the court ordered a rehearing for everybody denied. The mine worker came out to my law school and recruited about 8 or 9 of us. And we fanned out from Tennessee up to Pittsburgh and gave all these people hearings. It was a great experience.
Wild. Lindy, what about you? Tell us something.
Miners' life stories.
That's really wild, George. Lindy, tell us something about yourself that we wouldn't know if we only knew you professionally.
Mine is definitely less interesting than George's. This is probably only interesting to a very small subset of the population, but I'm really into doing crosswords. I do the New York Times crossword every day, and actually the longest period of time I went without doing a crossword was during the trial. I don't think I did a single one the entire month of December, and even when we finished, I just couldn't bring myself to do it for a little while. But that's one of my favorite things to do.
Do you do the crossword? Do you have to get inside the head of the person that's written the crossword puzzle? And if so, how do you do that?
I think it's less that and more noticing patterns. Something I've found is that the more you do them, the easier they get, in that even if they're not reusing clues, it's sort of the kinds of things they'll do. And if they do the sort of more puzzly ones where it's not just a fact, you're trying to answer some kind of riddle, you sort of get a sense for them as you're doing them, no matter who's the one who wrote it. Something I found is that, though, trying to start off doing the Sundays is not the strategy. You will not enjoy yourself if you try to start off with that. But yeah, I think it's less who wrote them and more just doing them a lot and seeing the same kind of stuff come up.
All right, George, back to you real quick. What advice do you have for a young lawyer that wants to get into the antitrust business? What experiences should they look for? what should they do to have a fulfilling career in antitrust?
Well, I'm going to answer the last part of that. I think the way you have a fulfilling career in antitrust is to love it, is to love all of the details that Lindy was describing that you learned during the course of these investigations, to be infinitely curious, and to really just have fun, to consider it a fun exercise that you would do even if you weren't forced to do it, if you can accept those words. So if you love the economic thinking, if you love the courtroom stuff, if you love learning about how everything works, I think you're cut out to be an antitrust lawyer. If you don't, I think probably the best advice is to find something else you do love.
And Lindy, what about you? What advice would you have for a young lawyer about, if they wanted to get into the antitrust world?
I think my advice would be to always be willing to try new things. I think it's very easy to do one type of case and enjoy it and say, okay, this is the kind of case I want to work on. But I think the best way to develop skills and to learn new things and to learn new industries is to keep working on things you've never done before and keep trying to do things you've never done before. And for me, working on this case, it was a constant exercise in doing something for the first time and doing something I've never done before. And I think I developed a lot faster and learned a lot faster than if I'd just been doing the same kind of things I was doing as a more junior associate.
What's your favorite thing about working in antitrust so far, Lindy?
So I really like the variety of industries and all the different kinds of interesting and weird facts you learn. I'm one of those people that's really into trivia and really into just sort of knowing useless random knowledge and having the ability to pull it out whenever I want, which is probably why I like crosswords so much. So if you're that type of person, I really think antitrust is like the best area of law.
It is. Yeah, Lindy, I thought you were going to say the best part of being in antitrust was the opportunity to work with George Cary. But
that too.
But let's go on to our final segment, which we call the Curious Hat.
And now it's time for the Curious Hat.
The Curious Hat is the final segment of our podcast. In the Curious Hat, I pull a question out of an actual hat, and I ask you the question that's on the card. Since we are not all together in the same place today, I'm going to ask you to choose a number between 1 and 15. And then I will read the question associated with that number. George, would you like to go first?
15, please.
Number 15. Okay, thinking that we had saved all the best for last. Okay, because this is a good question for you. George, what did you wish you knew when you started your career?
Wow. The thing I wish I knew when I started my career is that you can fix pretty much anything. That there is no task that you screwed up that you can't remedy at some point. I think when I was young and paranoid and compulsive, I worried about every little thing to an inordinate degree, which is not a bad thing, but at the end of the day, it's like carpentry or car repair or remodeling or anything else. If you make a mistake, it's not irredeemable. You can always fix it.
George, is there a particular episode you had in mind where something happened that was unexpected and you learned you learned just that lesson that things are fixable?
There's an episode I have in mind, but it's not when I learned it. It's when I wish I had known it. And that was, I was in charge of document production as a young associate, and a couple of privileged documents slipped through the cracks in the hundreds of boxes that went by. And I thought it was the end of the world at the time.
And I think it's funny. I think many of us have had that experience, and maybe even exactly that experience, where it not necessarily our proudest moment, but in the end, things. You're right. Things are generally fixable. Okay, Lindy, your turn. Choose a number between 1 and 15.
8.
Okay, going for the middle. That's also not a bad strategy. Lindy, what is your perfect weekend?
I think my perfect weekend would be spending Saturday walking my dog and spending time outside, assuming the weather is nice on this perfect weekend, and, just enjoying some time away from my condo. And I think my perfect Sunday then would be baking something and sitting on the couch and not moving until it's time to go to bed.
And the crossword, of course.
And the Sunday crossword, yes.
All right, Lindy, and tell us, what is your perfect work day?
I think my perfect work day is getting to research something really interesting and dig into it and spend time on that, and maybe have a couple calls or a couple meetings with colleagues to get some time with other people, and then just going home and spending time with my dog and time with my husband and, having a nice night. I think that would be a good work day.
Again, I thought the answer was going to be to have the opportunity to work with George Cary.
Well, that research project would, of course, come from George Cary.
George, Lindy, thank you so much for joining us, and we will see you next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.